Hello, everybody, and welcome to week 2 of Civil Procedure Law 5121 here at California Southern University. This week we're going to be talking about a very important topic. We will start our discussion of personal jurisdiction this week, which we will finish next week in week 3. Simply put, jurisdiction in the legal sense can be seen as the power to declare law. There are typically two kinds of jurisdiction that we will study: personal jurisdiction and subject matter jurisdiction. So, personal jurisdiction is the power of a particular court over a particular defendant. For example, let's say Bob lives in Los Angeles. He writes a scathing review of Big Burger Corp on Yelp. Big Burger is located in New York. Big Burger files a defamation lawsuit against Bob in New York. So the question would be, does a New York court have personal jurisdiction over Bob? Can the New York court assert its jurisdiction over Bob, even though Bob is not in New York and we can assume Bob has no contacts with New York? So the answer to our question would be no. Bob must have some connection to New York in order for there to be personal jurisdiction. The court will look at the number and the nature of Bob's contacts with New York. And so that's what we're going to be discussing today, is what contacts must a defendant have with the forum state being the state where the lawsuit is being brought, and that's the court that's trying to assert jurisdiction. What kind of contacts must the defendant have with that forum court in order for there to be personal jurisdiction, such that there's not a violation of the due process clause of the 14th Amendment to the Constitution. The first case we're going to talk about is a very famous case in civil procedure called Pennoyer v. Neff. And I can tell you from the outset that Pennoyer is not really the controlling case anymore. I know one of the big frustrations of law school is learning about complicated old cases only to have the instructor tell you that it no longer applies. I'm going to do that anyway because as a law student, you must have to grapple with Pennoyer. Everybody has to deal with this case. Few people understand it. There are t-shirts going around that say, "I still don't understand Pennoyer." But we're going to talk about it today, and then we will move on into the more modern cases that talk about personal jurisdiction. So in this case, Neff, who was a resident of California, hired Mitchell, who was a lawyer in Oregon, and then failed to pay Mitchell's legal fees. Mitchell turned around and sued Neff in Oregon, and when Neff failed to appear, because he did not live in Oregon and was constructively served with process by publication, and that's when, instead of handing someone a summons, you make a publication in the local paper to tell them that they've been served. So because Neff didn't get notice and he failed to appear in court, the Oregon court entered a default judgment against him. Mitchell then attached some land owned by Neff that was located in Oregon and sold it to Pennoyer to satisfy the judgment. So the question is, did this Oregon court have sufficient personal jurisdiction over Neff based on the constructive service of process for an attachment of land owned by Neff in Oregon to satisfy an Oregon judgment entered against Neff? In other words, did the court exercise sufficient personal jurisdiction over Neff to be able to enter a judgment against him and to take his land that was located in Oregon? So the rule that we're going to talk about discusses two types of personal jurisdiction. And this is when you're glad to be a law student in the modern age, where most of the Latin has been gotten away with, and there's hardly any Latin remains. But in this situation, there's going to be a little Latin for you. So the court discussed in rem jurisdiction versus in personam jurisdiction. So in personam jurisdiction literally means the jurisdiction over the defendant's person. You have jurisdiction over the defendant and all their property. In rem jurisdiction is jurisdiction over a defendant's property because it's located in the forum state. So if there was proper in rem jurisdiction, the court could attach the person's land, but it couldn't enter a judgment against the person as to all of his property that's not located in the forum state, because it only has jurisdiction over part of it. In personam jurisdiction, they have jurisdiction over the person and their property. So the court ruled that Oregon had in rem jurisdiction over Neff's land because it was located in Oregon, but it did not have in personam jurisdiction over Neff's person. Thus, the court did not have jurisdiction over Neff in a personal action, which is an action against Neff as a person and didn't really have anything to do with Neff's property. But it could have had jurisdiction over his property if this were a property claim. In other words, this is not a property case. This didn't have anything to do with Neff's property actually being in Oregon prior to the judgment. This was a case of unpaid legal fees, and a personal judgment was entered against Neff by the Oregon court, and the property was only taken to satisfy that judgment, but the case didn't actually have anything to do with the property. So the court said that there could be in rem jurisdiction over the property if this were a case that somehow dealt with that property claim. Let's say it was a foreclosure action against the property located in Oregon. The Oregon court would have in rem jurisdiction over the property. So, ruling the way it did, that there was no in personam jurisdiction, the court held that the judgment was void. There was an action against Neff personally, but it was not a property action against the property he had located in Oregon. Now, the court also held that if the property were attached prior to the suit, then that would have put Neff on sufficient notice that there would not have been a due process violation. So essentially, if Mitchell had it to do over again, Mitchell would have to get an order of the court that would attach the land prior to the suit, and the court held that that would put Neff on sufficient notice of the suit that his due process rights were not violated. So in conclusion, states can have jurisdiction over people or over property located within their state. So in personam jurisdiction is the court has jurisdiction over the person and can enter orders and judgments against that person, which can be satisfied by attachment of the person's property. In rem jurisdiction, the court has jurisdiction over property in the state with regard to determining ownership of the property. So the court, if there's just property in the state, the court can take jurisdiction over the property to make decisions of who owns the property. So under in rem jurisdiction, there are two different types, and one's called true in rem, where the court decides the ownership of the property as between one person and the entire world. So the court could look at Mr. Neff's property and say the true owner of this property is Mr. Neff, and he has the highest claim on this property as against the entire world. Quasi in rem jurisdiction usually decides issues of ownership just between two parties or two litigants. That would be that the court would look at the property and say, well, Mr. Neff has a better claim to this property than Mr. Mitchell does. Or what is going on in the Pennoyer case is the type 2 quasi in rem, where the suit actually doesn't have anything to do with the property, but the court can use the property as the basis for jurisdiction. So essentially, if Mitchell had attached the property at the beginning of the suit, that would have put Neff on notice, and the court would have been able to exercise the type 2 quasi in rem jurisdiction over Neff, where the court could hear the Neff would be put on notice, the court could hear the case, enter a judgment, and have the judgment be satisfied out of Neff's property in the state. The whole fundamental issue of personal jurisdiction and this due process violation is that the defendant has to be able to have some sort of reasonable notice of being sued in that state and a reason why they're being sued in that state. It can't just be that you send them a letter saying, I'm suing you in this state, and if I have no other contacts, that's insufficient to exercise jurisdiction. So the defendant has to have some sort of notice that their interests are at issue, and they have to have some sort of connection to the forum state in order for jurisdiction to apply. So that's the Pennoyer case. The differences between in personam and in rem and quasi in rem are all sticky issues, and it's a law school question. You don't really in the real world hear a lot about in personam and in rem jurisdiction. But let's move on to the modern cases, and these will talk a little bit more about the magic language that lawyers and law professors like to use. They like to have these certain buzzwords in your answers. So let's talk a little bit about that, and I've highlighted some of the buzzwords that you should keep in mind when learning about these cases. So the first real modern case of personal jurisdiction is International Shoe versus Washington from 1945. And it's a little strange that the first personal jurisdiction case would come down in 1945, some 80 years after the 14th Amendment was passed. Anyway, so the facts are that International Shoe was a company incorporated in Delaware with its principal place of business in St. Louis, Missouri. It had no contacts with the state of Washington whatsoever, aside from employing 11 to 13 salesmen that lived in Washington. The International Shoe owned no facilities in Washington, had no offices in Washington, did no advertising in Washington, aside from having these salesmen who would take their samples of shoes and other footwear around and try to make sales. So the state of Washington sought payment of money into its unemployment compensation fund pursuant to state law. International Shoe argued that Washington did not have personal jurisdiction over it and it could not be subject to a lawsuit there. The issue at hand is, were International Shoe's activities in the state of Washington sufficient to subject it to court proceedings in Washington within the Due Process Clause of the 14th Amendment to the Constitution? The rule that the court lays down in International Shoe is that for a state to subject a non-resident defendant to in personam jurisdiction, due process requires that he have certain minimum contacts with the forum state such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. And you'll see in many of these cases and in many areas of law, not just in civil procedure, law professors and I think bar exam administrators get really excited about certain magic words. So they're going to be looking for certain magic words and answers that you give. So I'm going to try to do my best to highlight those and point them out. And therefore, when you study these cases, you can study what the language is from the case that you should recognize. So in International Shoe, the court looked at the Due Process Clause and held that International Shoe did have certain minimum contacts with the state of Washington such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. You'll see the bold words there, certain minimum contacts, and does not offend traditional notions of fair play and substantial justice. Those are the buzzwords from the International Shoe case. So the court looked at the facts that International Shoe had no office there, was not incorporated there. It did not have any facilities in the state of Washington. It didn't make any contracts in the state of Washington, didn't maintain any stock in Washington, and it delivered no goods into Washington. However, it did have these salesmen in Washington who resided there and made their sales calls there. They each had a stock of samples. Sometimes they'd rent temporary rooms to display the products, and then the salesmen got compensated by the commission. So the court's conclusion was that this does not offend traditional notions of fair play and substantial justice. There were sufficient minimum contacts with the state of Washington. International Shoe had regular and systematic contacts because of its salesmen there. It profited off the business that was conducted in Washington. It profited off the protection of Washington laws. You would presume that if something went wrong with one of its salesmen in the state of Washington, that there would be a lawsuit brought in that International Shoe could bring in Washington to enforce its rights. So, it had the protection of Washington laws. And therefore, even without having a physical presence there outside of these salesmen, it did have sufficient contacts to satisfy due process. So there are several other modern cases that you're going to read this week about personal jurisdiction. I'm not going to do a detailed analysis of each one, but I do want to just run through them really quickly. The McGee case from 1957 has to do with an insurance policy. A California resident bought an insurance policy through the mail from an Arizona company, and then that company was then bought by a Texas company. The person in California died, and there was a dispute over payment on the policy. A lawsuit was brought in California, and the insurance company said that it sells no policies in California. It has no connection to California. So the court held that there was sufficient minimum contacts to satisfy due process. The contract had a substantial relationship to California. It was a contract that was delivered in California. The premiums were mailed from California, and the insured was a California resident. Therefore, California had a manifest interest in making sure its residents have a means of redress against insurers who refuse to pay claims. In other words, you can't sell a policy into the state of California and reap the financial benefits of getting premium payments from California and then argue that you're not subject to jurisdiction in California. In the Hansen case, 1957, a Pennsylvania resident established a trust in Delaware with a Delaware bank acting as the trustee. She then moved to Florida, did some trust administration activities there, and then died. A dispute arose over the trust. And then, so the issue was, does the Florida court have sufficient personal jurisdiction over the Delaware trust, which means, does it have jurisdiction over the Delaware trustee? The court had to look at the contacts that the Delaware trustee bank had with the state of Florida. So the court held that there was not sufficient minimum contacts to satisfy due process. The Florida court could not exercise jurisdiction over the Delaware trustee. The Delaware bank had no office in Florida, transacts no business in Florida, solicits no business in Florida by mail or in person, and even though the person who established the trust did some trust administration duties in Florida before her death, there was no instance where the trustee performed any kind of acts in Florida. So in the Schaefer case in 1977, there was a Delaware statute that allowed the Delaware courts to take jurisdiction over a suit by sequestering any property of a defendant in the state. So if a defendant was a non-resident and had no connection with the state other than owning property there, and a suit was brought, the Delaware statute allowed the courts to establish jurisdiction on the basis of the property being in the state of Delaware. So in this case, a plaintiff who was a Delaware non-resident filed a suit in Delaware against the officers and directors of a Delaware corporation whose principal place of business was in Phoenix, Arizona. The Delaware court seized the shares of the Delaware corporation owned by 21 of the defendants. So these shares were considered property within the state of Delaware, and even though the defendants were non-residents, the Delaware court said, well, your shares of your stock are in the state of Delaware. It's a Delaware corporation. Therefore, we're going to sequester those shares. We're going to take your property and exercise jurisdiction over you. So the Supreme Court expanded the rule from international shoe, which dealt with in personam jurisdiction, and applied it to this situation, which is in rem jurisdiction. So Delaware is saying it has in rem jurisdiction over the shares of stock that are located in the state of Delaware, and that's sufficient to satisfy due process because of Pennoyer. However, the court said, no, you must meet the rationale from international shoe. So the Delaware court must meet the minimum contact standard to exercise jurisdiction over property in Delaware in a lawsuit that's not based on the property at issue. So this wasn't a case where there was an issue as to who owned the stock. This was a different issue, and the stock was just being held as property to establish jurisdiction. So this was a quasi in rem situation. So in other words, the Schaefer court was saying that due process requires sufficient minimum contacts with the forum state in order for the forum state to exercise jurisdiction over the defendant. You can't just have the property in there if it's not a suit that's related to the property. The international shoe standard still must apply. Two last cases, a worldwide Volkswagen from 1980. The plaintiff bought a car from the defendant. The defendant was a car dealer in New York. The plaintiff was driving the car home to Arizona, but wrecked the car in Oklahoma. The plaintiff then sued the manufacturer and sued the car dealer in Oklahoma. The car dealer had no contacts with Oklahoma. It was a local New York car dealer. So the issue was, did the car dealer, who was a New York company, have the necessary sufficient minimum contacts is subjected to personal jurisdiction in Oklahoma? Plaintiff made the novel argument that it would be foreseeable for a car sold in New York to cause damage in Oklahoma. Cars are portable goods. They can drive all over the country. If you sell a car in one state, the plaintiff argued, you should reasonably anticipate that car could cause damage in any state where you could drive it. So the court argued that, even though it may be foreseeable that a car from New York could cause damage in Oklahoma, foreseeability is not really the standard. And the court, you'll see in the opinion, the court listed a number of different businesses, tire companies, things like that, where you could sell a good and it would end up in another state where you don't do business and then cause damage. So the court said that's not really the standard. The standard must be that the defendant has purposely availed itself of the privilege of conducting activities in the forum state. You'll see purposely availed as magic buzzword. In this case, the defendant's sole connection to Oklahoma is that a New York customer drove the car there on one occasion. There's no other connection. The court said it would be unreasonable to subject it to a lawsuit based on the one occurrence. The defendant's conduct must be such that he should reasonably anticipate being hailed into court there. So, from the worldwide Volkswagen case, you're going to see that the defendant must have purposely availed itself of the forum and could reasonably anticipate being hailed in the court there. In this case, the New York dealer did no business in Oklahoma, had no offices there, did no sales there, no contact whatsoever aside from this one person who bought a car and happened to drive it into Oklahoma and then wreck the car. So the court held that the car dealer did not purposely avail himself of Oklahoma and could not reasonably anticipate being hailed in the court there. The last case I want to talk to you about, and there are a couple more cases in your assigned reading, but this is the last case I want to talk to you about here. The Bruegger King Corp. And this basically has to do with whether a contract alone can establish personal jurisdiction. The plaintiff in this case was Bruegger King, which is a corporation located in Florida. They entered into a franchise contract agreement with a Michigan resident. The franchise fell apart, and the defendant stopped paying on it. So Bruegger King sued the defendant franchisee in Florida for termination of the franchise agreement. So the restaurant was located in Michigan. The defendant was located in Michigan. The defendant didn't have any locations in Florida, but plaintiff is Bruegger King. Bruegger King's in Florida. The contracts were entered into in Florida. So the court said, look, this is not a mechanical thing. We have to look at these cases on a case-by-case basis and determine if the facts of each particular case satisfy the due process requirement. Here, there was a Florida long-arm statute, and you'll see these where there's a statute in the state that says we can establish jurisdiction over the defendant who takes a certain action, commits a tort in the state, enters into a contract in the state, things like that, sufficient with due process. So here there's one of those statutes that the Florida courts say that they can exercise jurisdiction over a defendant within the state of Florida on one of these grounds. The defendant had no physical contacts with Florida. He never went to Florida, didn't have any offices there. The only thing was that there was this contract. So the court argued that there is jurisdiction because there are minimum contacts that were made, and the defendant purposely availed himself of the benefits and privileges of conducting activities within the state. So you see, the defendant here entered into a complicated franchise agreement. This was a 20-year relationship with the plaintiff, which included many contacts with Florida, payments being made and equipment being ordered and things like that. So the court said, look, this is not a case where there was, random or insufficient contacts. This is that somebody willingly entered into this contract in Florida and to establish this long relationship, this long franchise relationship. The court said that the defendant's connection with Florida can't be seen as random, fortuitous, or attenuated. So here, even though the person has no physical contact with the forum state, both of the parties are businesses. You would imagine that they're fairly sophisticated in these dealings. You enter into a contract in the state of Florida, and you can reasonably anticipate being hailed into court in the state of Florida. So in closing today, summary of personal jurisdiction. Pennoyer is a famous jurisdiction case. Everybody has to suffer through it. But really, International Shoes, the start of the modern standard for personal jurisdiction. Due process requires that the defendant have purposely availed himself of the forum state and have established certain sufficient minimum contacts with the forum state to reasonably anticipate being hailed into court there in such a manner as to not offend traditional notions of fair play and substantial justice. That sort of lays it all out in one summary although there's a lot of buzzwords in there. But really what you have to look at is what are the connections between the defendant and the forum state, and do those connections rise to the level of just meeting the minimum contacts requirement to exercise jurisdiction. We've seen contacts can be including maintaining an office there, advertising there, making sales there, entering into a contract there. They must establish a pattern that's not random or fortuitous or attenuated. So that's the rundown on this first week of personal jurisdiction. If you have any questions or other comments, feel free to post on the discussions or shoot me an email, and we'll see you next week.